Good morning. I am Emma Horowitz, and I'm a member of the Mino faculty. I teach English here. Thank you so much for attending my session. It is truly an honor to speak before all of you today. Some of you may be wondering how an English teacher came to be speaking about the presumption of innocence, legal history, and the ways in which justice is administered today. For those of you who don't know, in a past life, I was a prosecutor in the Brooklyn District Attorney's Office for about 6.5 years. Any lawyers here? Any lawyers in the crowd? Okay. Criminal?
No.
Okay.
I work for the Bronx District Attorney, though.
Oh, okay.
Yeah.
Great. Any Law and Order fans? Yeah, me too. It's just like that, except on a much, much longer time frame. Good morning. So you could say that I come by my interest in the law honestly. My father was an attorney. My husband's an attorney. My 9-year-old is an attorney, or at least better at arguing than most of the attorneys I encountered in my years of practice. He has both my husband and myself completely vested at this point. So this past year, with one of my 11th grade English classes, we read The Crucible by Arthur Miller, which I don't have to tell you is an incredible play, and one that concerns the Salem witch trials. And of course, it's an allegory for the trials happening in the House Un-American Activities Committee in Congress in the 1950s, in which Miller was unfortunately a part of. And while we were reading the play, one of my insightful, amazing students commented, "Wow, it really seems like in Salem, there was no presumption of innocence. Instead, there seemed to be a presumption that everyone was guilty. Everyone who was accused was guilty." Sorry. It's totally the opposite of today. So I thought about that at the time, and I thought, wow, that really seems pretty true. So this topic was born. And unfortunately, I've had to revise some of my initial assumptions after doing some research, but we'll get to that. So this topic, of course, also has a more timely application. We read The Crucible and learned about McCarthyism shortly after now Justice Kavanaugh's confirmation hearings. And the ways in which the Senate Judiciary Committee proceeded made me very uncomfortable as a lawyer, but I couldn't quite articulate why at the time. So I wanted to research more about legal history and find out how we moved away from witch cakes, which I will teach you about in a moment, and toward defendants' rights and the presumption of innocence that we all take for granted as part of our lives today. It's my hope that in learning about the past, we can inform the future, and that we as a country can begin to formulate a way forward, which we desperately need right now. So today's session will begin at America's beginning and look at some of the ways justice was administered in colonial America. Then we are going to look even further back into world history and examine how the presumption of innocence came into being. Finally, we will examine together how it is applied today, as well as its outer limits, before discussing its application in the Kavanaugh confirmation hearings. So part 1 is justice in the colonies. Trial by jury is a relatively modern invention. The title of this session promised to teach you about trial by ordeal, so although it was never really practiced officially in America, although certainly aspects of the Salem witch trials will sound familiar to those who know about trial by ordeal, we will definitely discuss trial by ordeal now. So trial by ordeal was practiced primarily in Europe during the Middle Ages. A religious judge, who was typically a priest, was the adjudicator, and the idea was something like this. If a man was accused of a crime, let's say stealing a neighbor's horse, the way to decide if he was guilty or innocent was by sticking his hand in, for example, a pot of boiling water. Now, if he was guilty, his hand would burn. Okay. If he were innocent, God would intervene and save him. So this system, with its fairly obvious shortcomings, persisted for about 400 years. Why do you think that might be? Why did this go on for so long? Miriam?
People have a really strong moral complex and moral pulls to say, okay, we have to prosecute someone so that we all feel safer in our own homes.
For sure. So the instinct that most societies have to protect its citizenry from evildoers, it spans time and place. Ms. Wagner.
So it would seem that there was a presumption of guilt.
Yes,
because
in many ways.
Today, yeah, if you combined with their religious sensibilities, that God will save you. Yeah, we know you're guilty because your hand is going to burn. Like
right.
At the end of the day, that's just it's almost an inevitable, and God is sort of is signing off on that because if you weren't, you clearly some divine intervention would have taken place, and you would have been your hand wouldn't burn.
Exactly. So there's a reliance on divine intervention here.
Well, I think there's also a reliance on self-defense because if you object to people having their hands stuck in boiling water, you might get your hands stuck in boiling water.
Right, and that's a mentality that we'll see throughout this analysis.
It supported the power structure of the church, so they had a lot of incentives to keep it going.
Sure, absolutely.
But I think also, to piggyback what you just said, there really wasn't much secular law.
At that time, there was, I think, no
Right.
secular law, essentially.
The church laws
Right.
dominated every aspect of your life.
Yes, but one sort of tachlis reason why this persisted for as long as it did is that it got results. Because if you were guilty, you were not going to stick your hand in that water because you knew what was going to happen to you. So you would confess, right? And then they wouldn't have to go forward with the ordeal. You were not going to do that. You knew exactly what would happen, not just because it's a cause and effect type of thing, stick my hand in boiling water, get burnt. You also believed in your heart, most likely at that time, that God was going to punish you in this way, and then everyone would then know that you were guilty. Whereas if you were innocent, you also believed that God would save you and your hand would not burn. So the defendant who was willing to stick his hand in that pot of water was probably innocent if he had that level of faith. So the priest might at that point say, okay, you'll stick your hand in the water in about an hour. And the priest was the one who was typically in charge of this type of adjudication. So they used boiling hot irons, but if someone was really intent on going forward with the ordeal, maybe they'd let the irons cool off a bit and check their hands in a few days to see if they still had evidence of a burn. So justice, in a way, was done, but thankfully England and in Europe, they more or less stopped doing this by the end of the 13th century and found a new way to do things. We could also compare this, sort of parenthetically, to the ordeal that the Sota had to endure in drinking the bitter waters. This also required divine intervention, for everyone was given the same mix of dust and water, but if the Sota were guilty, her belly would rupture and she would die, whereas if she were innocent, she would be asymptomatic. So we stopped doing this in about the 1st century, Common Era, but anyway, we could not do this without a Beit HaMikdash. So, skipping forward some time, some of the first Americans landed in Jamestown, Virginia in 1607. At first, it was only men and boys who came, and that first group struggled with survival. They weren't thinking about law and order yet, they were really just worried about making it through the winter at that time. The vast majority had died within 3 years, but England saw opportunity in the colonies, so they kept sending more people, and eventually the need for a system of laws became clear. There was one problem. The people who came were not lawyers. They were not educated in many cases, and they didn't really know a lot about self-governance. The legal system in England had been well established at this time for centuries, but the people who immigrated didn't really know that much about it. So the Virginia Company, which was the settlement's financial backer, imposed the Articles, Laws, and Orders Divine, Politique, and Martial for the colony in Virginia in 1611. So this was a pretty draconian set of laws, and one of the settlers wrote home to England and described the laws with some accuracy as tyrannical. So I'll read you a little excerpt from this letter now. The cause of the unjust and undeserved death of sundry, by starving, hanging, burning, breaking upon the wheel, and shooting to death, some more than half famished, running to the Indians to get relief, being again returned, were burnt to death. Some for stealing to satisfy their hunger were hanged, and one chained to a tree until he starved to death. Others attempting to run away in a barge and a shallop, all the boats that were then in the colony, and therein to adventure their lives for their native country, being discovered and prevented, were shot to death, hanged, and broken upon the wheel, besides continual whippings, extraordinary punishments, working as slaves in irons for term of years, and that for petty offenses were daily executed. So this was not really a pleasant time to be alive. It was a very difficult life, and the laws really reflect that. Many of the crimes in pre-colonial America were, as we saw in Europe, also religious in nature. Church attendance was required, and in many towns there was a special vod, if you will, appointed to check attendance on the Sabbath. Improper behavior on the Sabbath was strictly prohibited. Some examples of that are laughing, not allowed to laugh on the Sabbath, and sleeping. There was a case in Boston in the early 17th century where a man named Roger Scott was arrested for repeated sleeping on the Lord's Day. He was sentenced to whipping for, and I quote, striking the person who waked him from his godless slumber. So thinking back to yesterday, I'm sure we can all relate to this very human impulse that Mr. Scott showed in lashing out on the person who came and woke him from his Sabbath nap. A sailor who returned from 3 years at sea on a Sunday, happened to disembark on a Sunday, kissed his wife in public at their reunion, and was punished by spending hours in the stocks. But just even apart from Sabbath observance, most of the laws were religious in nature and were punished in public. We could talk literally for hours about Puritan punishment. It's fascinating. Anyone in here read the Scarlet Letter recently? Yeah. You remember Hester Prynne's punishments? She had
Or
to
watch
stand.
the Jamestown series.
Right. So she had to stand, Hester Prynne, obviously a fictional character, had to stand on the pillory holding her newborn baby and then wear the scarlet letter for the remainder of her life, right? Suffice it to say that rehabilitation of the criminal was much less important to the Puritans than publicly shaming them for the purpose of deterrence. Anyone who considered breaking the law in the future might be deterred by what they saw happening to criminals in public. Punishments were very, very public. They drew large crowds, not only as a warning, but also as entertainment, because this was a society that prohibited just about everything we consider to be entertaining today, such as music, dance, theater, laughing in many cases, or even gossip. Gossips were sometimes punished by hours on the pillory with a special mask over their mouth to show why they were there. So the process through which these punishments were determined is also of interest. The colonies' legislatures were regulated by their charters from England, which instructed them not to make laws repugnant to England's legal norms. The charters were typically silent, though, about the court administration aspect of how justice was to be administered. Very possibly the authors of these charters sitting in England really didn't have much idea about what was going on in the colonies and just figured that courts would be run in the same way that they were back in jolly old England. But by 1681, when Pennsylvania got its charter, the instructions were starting to get more specific, so they were probably realizing that that was not in fact what was going on. But that being said, many aspects of the British court system, especially as more educated people started to come over from England, began to develop in the colonies. So this is a good time to look at the Salem witch trials as evidence of how trials were conducted in colonial America. The process for trying people, and as we all know, usually these people accused of witchcraft were women, but not exclusively. It was not so different from the way criminal justice is carried out today. A person could be accused of witchcraft in two different ways, basically as a violation of two different statutes. Number one is causing affliction to a specific victim, like I have enchanted Miriam, for example, or number two would be covenanting with the devil. So these are two separate crimes. A special court was convened in Salem called the Court of Oyer and Terminer, meaning to hear and determine in kind of a blend of French and Latin. And this court existed only from May to October 1692. 9 judges were appointed to this court by the governor of Massachusetts. Evidence was given to a magistrate, an arrest warrant would then issue, a grand jury would hear the case, and if the grand jury returned a true bill, meaning it found that sufficient evidence to prosecute existed, the case would go to trial, and that was often on the same day as the true bill was handed down. Sentencing then followed conviction, also typically fairly swiftly. The evidence that was presented to the grand juries, and if applicable at trial, was not the same, let's say, as the types of evidence that we're familiar with today. For example, physical examinations of suspected witches were conducted. They were looking for witches' teats. Don't ask me what that looks like, I have no idea. But apparently the people conducting the examinations knew what to look for. The witch cakes, which are perhaps the most grotesque, were also made, and what that was the urine of a suspected witch was mixed into a cake. That cake was then baked and fed to a dog. If the dog died, then the person whose urine was in the cake was a witch. If the dog lived, then not. Amazing. Some of the most compelling evidence in these cases, though, was called spectral evidence. So I'm going to quote a definition of spectral evidence from a New Hampshire case for you. Spectral evidence refers to a witness testimony that the accused person's spirit or spectral shape appeared to him or her witness in a dream at the time the accused person's physical body was at another location. The evidence was accepted on the basis that the devil and his minions were powerful enough to send their spirits or specters to pure religious people in order to lead them astray. In spectral evidence, the admission of victims' conjectures is governed only by the limits of their fears and imaginations, whether or not objectively proven facts are forthcoming to justify them. In other words, it was compelling evidence that a victim, in this case specifically, saw the specter of John Proctor sitting on a magistrate's lap while John Proctor was not in the room. Spectral evidence was significantly inadmissible in other types of courts outside the Court of Oyer and Terminer. The judges appointed in this court were not trained lawyers, but they were mostly laymen or clergymen. The governor of Massachusetts at that time was Sir William Phipps, and he was the person under whose authority the Court of Oyer and Terminer had been established. He issued a gag order barring publication of the trial records or discussion of the trials in newspapers. So under these favorable conditions, as you can imagine, chaos reigned supreme. The court in Salem ordered the hanging of 19 convicted witches. One man named Giles Corey, who was accused of being a wizard, refused to enter a plea, and he was held in contempt of court. The punishment for that was that he had to lie flat and heavy stones were placed upon his chest until he would speak. He wouldn't speak, so the stones crushed him. So he was the 20th victim. Around September 1692, intellectuals in Massachusetts began to push back against this gag order and publish strong critiques of what was happening. An influential Puritan minister named Increase Mather, who was the father of the perhaps more famous Cotton Mather, came out publicly against the use of spectral evidence. Shortly after that, in October 1692, Governor Phipps disbanded the Court of Oyer and Terminer, while the Supreme Court of Judicature, which was more like a trial court at that time, continued to prosecute witchcraft. Without spectral evidence, perhaps unsurprisingly, their conviction rate dropped, and no more executions occurred in Massachusetts for witchcraft. So my student observed that this court did not seem to have anything close to what we consider to be a presumption of innocence, which is an assessment that I wholeheartedly agreed with. So now let's turn to the development of that presumption of innocence, as well as the study of its boundaries. The legal presumption of innocence goes all the way back to the Code of Hammurabi, written in ancient Mesopotamia, currently Iraq, in approximately 1792 to 1750 before Common Era. The Code of Hammurabi was an extremely influential set of laws promulgated by the Babylonian king, who sought to punish injustice and protect widows and orphans. While the code was often violent, which reflects the era in which it was written, it also contains the first vestiges of a presumption of innocence. The code tells us, if anyone bring an accusation of any crime before the elders and does not prove what he has charged, he shall, if it be a capital offense charged, be put to death. In other words, if you accuse a man of a crime, you had better be able to prove it. You can't just have your neighbor prosecuted for stealing something because you don't like him, which is something that we see all the time. You'd better be able to prove it, otherwise you yourself will be put to death. So this is a fantastic incentive structure, obviously, because who will bring a weak case to court under these circumstances? This principle developed over time and has been applied in diverse times and places ever since, as have other rights for people accused of crimes. The Greeks had such a principle. The philosopher Demosthenes said in 352 BCE that a person accused of murder may not be called a murderer because no man comes under that designation until he has been convicted and found guilty. The Romans, and let's remember these are the same people who made a public sport out of feeding Christians to lions in stadiums, also had this. They say no man comes the Romans said that people who had been accused but not convicted of crimes retained the rights to inherit property and also to conduct business. There was a constitution from the year 382, a Roman constitution, that stated explicitly that only an accusation backed up by reliable witnesses, documentary evidence, or undoubted facts could proceed. The Romans also had laws guaranteeing defendants a right to a speedy trial and the right to bail in many cases. While Jewish law doesn't have an explicit presumption of innocence, it is so difficult to obtain a conviction that this is its own type of protection for criminal defendants. Essentially, throughout cultures, throughout time, it has long been understood that not everyone accused of a crime is a criminal, and that the justice system must protect all of the accused, because it is very often unclear from the outset of any given criminal proceeding who is guilty and who is innocent. It is a fundamental principle of a fair criminal justice system that the rights of the accused matter just as the rights of a victim also really matter. The first use of the term innocent until proven guilty was in 13th century France. It caught on quickly. Law students in France began learning it in the late Middle Ages. During the Middle Ages and the Renaissance in France, however, the monarchy of the old regimes significantly limited this concept. People accused of crimes were not permitted to hold positions involving the public trust and often were not entitled to bail. Longer and longer periods of pretrial incarceration became common, and even torture of criminal defendants for the purpose of attaining a confession was often occurred. The monarchy felt that those who spare the guilty punish the innocent. It was not a good time in history to be accused of a crime. Of course, it was also not a great time to be poor, and the old regime was eventually overthrown during the French Revolution. In 1789, after the Revolution, the presumption of innocence was codified into the French Declaration of the Rights of Man and of the Citizen. Unfortunately, after the brief idealism of the French Revolution, the 19th century saw a return to restricted rights for those accused of crimes, and it became understood that in France, defendants were essentially presumed guilty. A British reporter writing on the Dreyfus Affair in France reminded his British readership how lucky they were to live in a land where defendants were innocent until proven guilty and not the opposite. Is everyone familiar with the Dreyfus Affair? Okay. So in England, there's a Latin phrase, which I will not attempt to pronounce for you, which means that everyone is presumed to be good until the contrary is proved. This phrase originated in the Middle Ages but became very popular in the 17th century. It found its way into plays and poems, but also lawyers began to take it to heart. In court, both in England and Scotland, the burden of proof, both in civil and criminal cases, began to lie with the accusing party. Scotland has a little bit of a different legal system. They're not pure common law like England, but they have a mix of civil law and common law. And there, the rights of the accused went even further and even earlier. All criminal defendants were entitled to representation by attorneys as early as 1587. Very progressive. Here in America, before the American Revolution, the presumption of innocence was also known. A colonial court in 1657, even before the Salem witch trials, from the Massachusetts Bay Colony made reference to the principle that, and I quote, "In the eye of the law, every man is honest and innocent unless it be provided legally to the contrary." After the Revolutionary War, more and more cases made reference to the presumption of innocence, and it became clear that this was a generally accepted common law principle in America. Interestingly, the federal Constitution has no language at all guaranteeing the accused the presumption of innocence, although some states, such as Rhode Island, do provide this guarantee in their state constitutions, and in many cases the language mimics the language from the French Declaration of the Rights of Man. That seems to be the source for many of the state constitutions, as they were similar in time. The United States Supreme Court, however, addressing the lack of a federal right, addressed the issue in the 1895 case Coffin versus United States, which, despite its caption, was not a murder case, but actually a bank fraud case. And the Supreme Court held that the principle that there is a presumption of innocence in favor of the accused is the undoubted law, axiomatic and elementary, and its enforcement lies at the foundation of the administration of our criminal law. So now let's take a minute and understand the two different ways in which we can think about the presumption of innocence, either as a shield against punishment or a rule of proof. So let's begin with rule of proof. This refers to the common law principle of the burden of proof lying with the accusing party and not the accused party. This is a rule of procedure and nothing more. The state must prove its case against a criminal defendant beyond a reasonable doubt. The defendant does not have to prove anything at all, and indeed the defendant need not put on a case. In fact, the first trial I ever watched at the district attorney's office was as an intern. I watched a first-year assistant try a woman for stalking, and the defendant did not put on a case at all. The attorney didn't even cross-examine. He just said no questions, because the state's case was so weak that it just did not make out the charges, and the defendant was acquitted because there just wasn't enough evidence to go to trial. It was unclear why it went to trial in the first place. There was probably a reason that it had to, but I wasn't privy to that reason. So it was difficult to understand from a judicial economy perspective why this had happened, but the defense put on no case whatsoever and still obtained an acquittal because the burden is completely on the state. So the Fifth Amendment gives the defendant the right to remain silent, and thus he need not testify. And the state has to meet its burden of proof, otherwise that's it, the defendant is not guilty, and that's the end of it. So this is a view that is widely held and accepted by jurists, legislators, politicians of all backgrounds. Everyone can agree on this. It is a fact of American jurisprudence that criminal defendants benefit from this rule of proof because it is preferable, philosophically, to let guilty people go free rather than to send even one innocent person to jail. I think many of us can understand that, right? You can imagine the hardship of being sent to jail if you really truly have done nothing wrong. It's much worse than letting a guilty person go free, in the eyes of most commentators. Next, we can think of the presumption of innocence as a shield against punishment. This is a much more substantive and broader principle than a simple rule of proof. This is an ethos. This is an entire philosophy. The people who have been accused of crimes must never be treated as criminals. Instead, they should be treated with humanity and dignity unless and until they are convicted. This comes as more of a package deal of rights held by defendants, such as the right to counsel, which was not a given in most of American history either, the right not to testify against oneself, the right to appear in court in plain clothes rather than an orange jumpsuit, and so on. These are defendants' rights. The right to a speedy trial, also constitutional guarantees. Significantly, part and parcel of the second framework may be that a person accused of a crime might not even need to be arrested or indicted. It would be consistent with this philosophy to approach all those accused of crimes with this attitude until conviction, the person deserves dignity and the benefit of the presumption of innocence. As recent events suggest, however, this may not be the case. In the 20th century, the Supreme Court effectively reduced the presumption of innocence to a rule of proof, and there's case law stating that the presumption of innocence is just another way of saying that the prosecution has the burden of proof and nothing more. The Bail Reform Act of 1966 was Congress's response to the Supreme Court's narrowing the presumption, and came from the idea that bail should be granted as a means of guaranteeing a defendant's return to court, which is its purpose, and that if bail was not granted where appropriate, it violates the defendant's presumption of innocence. And this is obviously a pretrial application, because certainly at a bail hearing, at a defendant's initial bail hearing, the trial is still many months in the future. This is just someone who's just been accused or indicted, because there's a second bail application at that time. Yet under President Nixon, a bill was proposed that allowed judges to hold defendants before trial if they presented, and I quote, a danger to the community. This bill wasn't passed, but it was true then, and it remains just as true today. Defendants awaiting trial sit in jail and are treated the same way as those serving their sentences. In New York, which is the system I can speak to, criminal defendants awaiting trial who can't make bail or are not entitled to bail for whatever reason usually sit in Rikers Island, which has been the subject of many human rights concerns, and they sit in the general population in Rikers Island along with people who've been convicted of misdemeanors. They're not sent upstate, right, to Coxsackie or some far-flung state prison, but they are kept local for their trial, but they're treated exactly the same way as the people who've been convicted. So, the Department of Justice under President Nixon argued that the presumption of innocence was merely a rule of evidence and does not apply to pretrial proceedings. The Supreme Court, under the very conservative Chief Justice William Rehnquist, held in 1979 that indeed the presumption of innocence has no pretrial application. In other words, it only applies to criminal defendants during criminal trials, and that's it. Which I think from hopefully the past half hour of me talking, you can understand is not the historical context, right? The historical context is that from the moment of accusation, you're entitled to this presumption. But it's been narrowed and narrowed and narrowed so far that now we have case law saying it's really only for criminal defendants, only during trials. That brings us to today, September 2018. A man named Judge Brett Kavanaugh was in the midst of the most arduous job interview one can possibly imagine, his Senate confirmation hearings to become an Associate Justice of the Supreme Court. So the procedure works like this. Under the United States Constitution, in Article 2, Section 2, Clause 2, the President has the power, and I quote, to nominate, and by and with the advice and consent of the Senate, he shall appoint judges of the Supreme Court. Typically, the way this works is that the Senate's Judiciary Committee assumes the task of conducting hearings. If the Judiciary Committee votes to approve the candidate, then the vote moves to the whole Senate. If the candidate receives a majority vote, then congratulations, that candidate is the newest Justice of the United States Supreme Court. So in the case of Justice Kavanaugh, in July 2018, President Trump nominated him to fill the seat vacated by Justice Anthony Kennedy. At the time of his nomination, Justice Kavanaugh was a very well-regarded judge on the United States Court of Appeals for the District of Columbia Circuit, which is a very, very common place for presidents to go justice shopping, if you will. So like a springboard. On September 4th, 2018, the Senate Judiciary Committee began its confirmation hearings. Towards the end, and some might say at the 11th hour, an allegation came forward that Justice Kavanaugh had sexually assaulted Dr. Christine Blasey Ford back in 1982 when both parties were in high school. The Senate Judiciary Committee postponed its confirmation vote and allowed both parties to speak. The Judiciary Committee, in addition to a sex crimes prosecutor from Arizona named Rachel Mitchell, questioned both Justice Kavanaugh and Dr. Ford. Sometime later, the Judiciary Committee voted to send the nomination to the full Senate, but also requested a week-long FBI investigation into these sexual assault allegations. At that time, there were 3 allegations from 3 separate women. The vote proceeded, and on October 6, 2018, Justice Kavanaugh was confirmed by a vote of 50 to 48. This vote has been called one of the most partisan confirmation votes in American history. One senator from each side abstained, one because his daughter was getting married, and the other out of deference to the senator whose daughter was getting married that day. One Democrat voted yes, otherwise the vote was strictly down party lines. So the public interest and uproar surrounding this confirmation really can't be overstated. Justice Kavanaugh may have been confirmed, but his reputation will never ever recover. For many of us, no matter what his voting record or his accomplishments on the court may be, when we hear his name, we will remember these allegations. I'm not here to tell you that I have any idea personally whether he did this or didn't do it. I wasn't there. I assume no one in this audience was there. We don't know. We're just not qualified to speak to that. We are, however, qualified to speak to the process, and that's where the problem lies, in my opinion. It is worth noting that Senator Chuck Schumer, a liberal Democrat known for his allegiance to social justice issues, went on record saying, Justice Kavanaugh is not entitled to any presumption of innocence. This is a job interview. This isn't a criminal trial. Senator Mitch McConnell, a conservative, opined that he believed that Justice Kavanaugh was absolutely entitled to a presumption of innocence. This role reversal, this partisan role reversal, is an indication of an identity crisis. It's also a signpost for us and a warning of the dangers of injecting the fundamental national beliefs that make us who we are with partisan politics. Is the presumption of innocence a mere law of evidence with an extremely narrow application during a criminal trial? Or is it a broader philosophy that makes us who we are? I would argue the latter. The concept's history bears this out, and it is hard to overstate the damage that can be done to an innocent person accused of a crime if he or she does not have the benefit of this presumption of innocence from the moment of accusation, no matter what the forum is, if it's a criminal court, the Senate, or the court of public opinion. Fundamental principles of justice should not be reduced into a virtue signaling contest on Twitter. Trial by hashtag is dangerous and unwise. Giving people the benefit of the doubt up until the moment of their conviction makes us who we are, and if we take that away, I suspect we might not like what remains. Any questions? Any thoughts? Yes.
I think it's a totally inappropriate question about a Supreme Court justice. If he was that worried about his reputation and he had that much to lose because of his behavior as a young person, he could have withdrawn.
Right.
He was not charged with any crime. He was not put up for trial.
Right.
And the question is he an appropriate person to have a lifelong job on the Supreme Court?
Right.
Given his behavior, answering questions and his outbursts, many people think he was not dignified, he was not
right.
judicious,
right.
and there was nothing wrong with people coming forward with the kinds of concerns that they have if he's the right person. It is a job interview.
Yes.
And he's got control over the United States culture and court rulings. He was probably put in because of his willingness to pardon, I think, is a horrible president who may be accused of crimes, and if there's impeachment hearings.
Interesting.
So
if I recall, there was also discussion that when he had been confirmed by the Senate to his previous post,
Mm-hmm.
he had lied.
Mm-hmm.
So there's a lot of, the picture isn't just Dr. Ford.
Right.
And in addition, for me, what was most troubling was his way of handling these accusations, I'll call them, because it's not proven or
right.
anything.
Right.
But for somebody who admitted his high school years were a blur,
right.
and then say it couldn't have been me.
Right.
So if you go around drunk all the time,
right.
How can you use that as a defense?
Yeah,
and
I think that's a great point.
He's supposed to be a brilliant lawyer.
Yes. Yeah,
so
his judicial record was clean. He had a beautiful record. He was highly recommended, actually, by both sides of the aisle in many ways for his integrity.
Right, you may not like his rulings, but
right.
he
was supposed to be
is such a great legal mind,
100%.
and then use a defense
right.
that is so poor.
Right, so I will tell you that as a woman...
if somebody accused me of something terrible and I knew I drank for like 4 years straight, and one of my best friends wrote a book that basically admitted they did these things, and that to me also was like suppressed evidence. So I don't know why that guy wasn't subpoenaed.
So 2 points about that. I have a lot of personal ambivalence about this whole situation because as a woman who attended secular college, having been to frat parties, it's really, in a way, very satisfying to me to see men who behave badly as teenagers being called to task for that, called to account for that when they're older. I think that there's something, in a way, very satisfying about that. On the other hand, I think the process has to be fair, and it has to be a proper process. So the appropriate thing, that if he really were accused of attempted rape, there is no statute of limitations on that crime in Maryland. So this would be a state law issue, not a federal law issue. If this were a crime that she could substantiate in any way, the proper process would be to go to the Maryland authorities, and at least in New York, you can indict someone without even an arrest. It's called an ex-indictment, and it's done all the time. My first case in front of the grand jury was an ex-indictment, actually. So you can do that, and if there's enough evidence, then they'll seek an indictment, they'll indict him. That could have been done, and it wasn't done in this case. Instead, the way it was done was really, to my legal mind, quite appalling.
That's the question mark hanging over him.
Right.
Why all this cloudiness?
Right.
And, like his opinions as a justice or not, he does have a dark cloud over his head, and
Forever.
he always will.
He always will.
Well,
Yeah.
that's not his fault. I part of my perspective on this is I had a male relative who was falsely accused of something horrible. And were it not for the presumption of innocence, were it not for due process,
Right.
he could be in jail now.
Yeah.
And it was based on one person saying something to one other person that was kind of like a rumor, and and you know what?
Right.
If I would have been, if I had been accused of something like that, if I had been accused, I would not be judicially temperament, not
Right.
have judicial temperament. Maybe
Right.
then for I'm not proper to be a justice, but when something is that outrageous,
Yeah. Yeah, his temperament seemed to many people to be unbecoming of a justice, and maybe that's better evidence even than the charge. But on the other hand, I know that many people, when they feel so powerless, which he must have at that time, because he couldn't it's very hard to prove you didn't do something, right? Unless you have a witness.
And
very, very hard.
And that's very telling.
Yes.
That his temperament turned so radically different.
Yeah.
It was almost watching somebody thinking, this can't be happening to me because I've always been a
Privileged white man.
Exactly.
Yes.
A privileged white,
Right.
middle-aged
dare you.
guy.
Yeah.
I'm a privileged white female and I wouldn't want anything.
I guess further, I thought your legal analysis was great.
Thank
The
you.
historical analysis I thought was also great.
Thank you.
But then when you applied people have a right to be treated fairly in a criminal justice system.
Yes.
But they don't have when they're facing the loss of liberty. Someone said.
Right.
But no one has a right to be a Supreme Court justice.
Correct.
And as far as the process goes, you're absolutely going to have a different process when you're
Right.
facing the loss of liberty
Right.
than the process of, as you said, it's an advise and consent.
Right.
It's a political process.
Yes.
And there really isn't those
Entitlement.
criminal safeguards, nor should there
100%.
be. And when someone is,
Right.
like someone said, facing the prospect of being on the Supreme Court for the next 40 years,
Mhm.
I think he should be subject to a very, maybe not a trial by
Tough
ordeal,
scrutiny.
Right.
but, a very
Tough
strict scrutiny,
Yes,
And
absolutely.
as far as his demeanor, Justice Brennan said that he couldn't believe that a judge would take shots at the Democrats on that panel.
Yeah.
Right.
And basically bait them.
Right.
And I guess we'll just have to see what
He
his
berated
record
them.
shows.
He
Yeah.
berated them.
Right.
Yeah,
That's
but,
not his place.
But I think
Right.
I loved all that stuff about the Salem witch hunts and
Yeah.
Thank you.
the Code of Hammurabi. I'm wondering if there's any really evidence, I guess, with respect to what you mentioned, the Sota. This is a different topic.
Right.
Is there any evidence that the Sota ordeal was actually historically practiced in the Second Temple period?
My understanding is that it was, but I'm sure it wasn't so common. It stopped before, we didn't have a Beis Mikdash anymore, but it was, I think, put into practice. Now,
And what's the
historically
evidence for that?
speaking,
Is there any evidence for that it was practiced other than the
Who
Torah?
kept records of these things?
yeah, they did.
kept records?
I read a couple of legal articles that referenced it actually happening, and there some commentators think that it may have been a euphemistic for a miscarriage, that they induced a miscarriage, so it could be that the woman was pregnant at the time, and that was the context in which they did this. If she were pregnant and her husband disavowed the pregnancy, it could have been that was when it was done primarily, which would also make sense historically, right? Because they did know how to induce miscarriages at that time. So
It's a pretty horrific prospect.
yeah, exactly.
Yeah.
But I think it was practiced, although probably not on a totally widespread. It could only be done in the Beit HaMikdash, so it wasn't accessible necessarily to everyone. But
Thank you.
yeah, sure. So I want to also respond to what you said about the fact that it's not a criminal trial.
Right.
So 100% agreed, absolutely. But it could have been, and that's where
Maybe it will be.
I think if it were to have been, I think that ship has sailed at this point. It seems very unlikely to me that he would be indicted based on my experience, and you also were a prosecutor, so you can agree or disagree, but in my experience, this was not a case that I could imagine ever getting indicted, because even in cases where there's a single witness, and that aren't sexual assault cases, even in cases like, let's say, a robbery, right, where you have a single witness, we very often didn't put those cases into the grand jury because, especially across races or in circumstances where there's an ID issue, juries really don't like those cases. So often, even just indicting them is a waste of judicial economy because you know you're going to get an acquittal at trial. The evidence is just not strong enough. So he said, she said, from 1982 doesn't sound like an indictable case to me personally.
But you're forgetting
Bill
about the
Cosby.
best friend with the book. And he was probably the witness in the room.
Then he would have to be compelled to testify, and who knows if he
and
would.
why did not that happen?
Well, I would guess that there's a reason why that didn't happen.
In the calendar.
There's probably actually a few good reasons why that didn't happen, and why it probably won't happen.
Yeah, well,
I don't think it will happen. And the fact that it could happen, though, to me is enough of a trigger for a presumption of innocence. Like, I think that although I spent 6 years essentially, if I were to badly describe the job of a prosecutor, it's putting people in jail, right? It's a very bad, very, very bad description. But although that was my career for a time, and I very, very strongly identify with the need to protect the public from predators, like, you will not find me denigrating victims' rights ever. I just think we also have a responsibility to the accused in that we need to keep in mind that this is someone's life also. Now, there's certainly not an entitlement to be appointed to the Supreme Court, 100%, but the fact that the man passed numerous FBI investigations, you can't just get to his position of trust without having the FBI poking and probing. I've been somebody's reference who worked for Governor Scott in Florida. I know that these calls they know everything about you. They really dig very deeply.
They had no way. How would they know
Right.
this unless this woman came forward?
Well,
It's not in the record. They don't know it until she.
Right.
And
that
she may
FBI
not. She may not
investigation
have
was-
been.
Yeah.
She may have
My
known that
son's
the
calls were a reference.
that the criminal evidence was very weak,
yes.
and things in 1982 were the probability of prosecuting rape cases was very low. It wasn't a likable thing for prosecutors to do. Went on with her life.
Right.
But to see him be nominated for the Supreme Court.
Session number 1 should wrap up in about a minute, and we will still start session number 2 at 11:45.
It's also
Thank you.
Sort of intriguing to me. Why wait till that moment? If she was following his political career,
She probably wasn't.
Well, she probably was. I think.
I don't know.
It sounds like when you get appointed to the D.C. Circuit Court of Appeals, that's, as I said, is where presidents tend to go when they're judge shopping.
But if you're not in the legal
She's in
profession and not
California.
following,
Right.
I have no idea who's
Right.
on the
I don't think he was
DC
in the headline.
Court of Appeals. I have no idea.
Yeah.
who
He was
is.
certainly in legal.
If you're not in the legal
He was
profession,
in
you
legal.
don't know.
Why should
But
she-
you don't know. The regular people
Why
don't
should
know.
she subject herself to that?
Right,
Right.
Why should she
right.
have
I would imagine she put it in the box.
She was
Yeah.
not
Yeah.
really counting
His
on it.
life
We're talking
would have
about Twitter
gone
here.
on
Everything
very
is out
well.
there right away.
Yes.
And people from both sides become impassioned and inflamed about what they see.
Right.
And I think that's our bigger issue today,
Yeah.
is that we've become so divided, because it's not just Brett Kavanaugh, it's everything that comes up.
Right.
Every legal matter, every criminal case.
Very true.
And,
The
where a white
confirmation
supremacist
hearings-
who kills 11 people will have supporters out there also in
Right.
droves,
Yeah.
who of his like mind, because they can instantaneously message each other
Right.
and cause a divide that's even greater than it was before.
In the 1970s,
So-
many of these confirmations were unanimous.
It's just
What was wrong with
symptomatic
Justice
of a
Garland?
system today.
Yeah.
Yeah.
Justice Garland.
That's right.
Right, it's just symptomatic
They
of where
considered
we are
him.
today.
They didn't meet with him.
There
I
were
know.
never hearings. There were
Right.
never hearings.
That's the answer that they say is, well, we thought about it and we decided not to hold the hearings.
And he
No.
Which is
Didn't he
crazy
cook
also.
for Garland? Didn't he work for him or cook for him?
There was something like
Yeah,
that.
yeah.
There was.
Uh-huh. So it's like if you can't
Garland's
bring
squeaky
yourself to
clean.
do Garland, let's do
Right.
Garland till what he
Right.
points to or whatever they call it, you know?
Pretty different philosophies.
Well, thank you.
Thank you all so much.